Hey y'all, Gary here with Tennessee Stands. Hey, you might know that on Friday, June 2nd, a federal district judge out of West Tennessee ruled that the law that passed this year that prevents minors from being exposed to sexualized performances, to obscene performances here, such as sexualized drag performances. Federal judge on Friday ruled that law unconstitutional. And I want to take you through this. It's a 70-page court order, but there are some really incredible things said in that court order that I think are dangerous when we think about this ruling making its way to the Sixth Circuit Appellate Court, and most likely the Supreme Court, and the implications that could have depending upon how the Supreme Court will actually rule. But I want to take you through some of this judge's statements. But here's one big takeaway, right? Before I dig into the details. I want to make sure that everyone that watches this video understands that this, contrary to some of the reports that you're seeing, this law was not struck down and declared unconstitutional across the state of Tennessee. Specifically, Friends of George's, which is a nonprofit based out of Memphis. It's a nonprofit LGBT theater, right? Based out of Memphis, sued in federal court over this new law. And they sued Memphis District Attorney Mulroy, I believe is his name. To make certain you understand what happened here, the court permanently enjoined the Memphis District Attorney from being able to enforce this new law in Shelby County, in his district. So, to be clear, this court ruling does not extend to any other district attorney throughout the entire state of Tennessee except the Shelby County Memphis District Attorney. That's it. So, only one county out of all 95 counties in the state of Tennessee is unable to prosecute and enforce this law. That's critical, because here's what we need to fight the judicial activism that we're seeing from this bench. DAs across the state of Tennessee need to be prosecuting in their own districts when this law is broken. And sure, that may take them back into court, but it's worth it because, number one, we could use a competing court ruling against this idiot out of West Tennessee. But secondly, we can't bow to the courts. The court cannot extend its power beyond the jurisdiction that it's been given. I should have said that the opposite way. Nonetheless, that's an important point to understand. This law is not blocked or enjoined or declared unconstitutional across the state. That is what some outlets are reporting. That is absolutely false. All right, that being said, the second quick thing I want to say before I dive into the ruling, I need you to understand something. And I say this all the time, that it's not about Republicans and Democrats. It's about good and evil. All right? And please hear me. This judge in West Tennessee that ruled this law as unconstitutional per the First Amendment is a Republican. Further, this is a Trump-appointed judge. That is an incredibly important distinction for everyone to get. I say this all the time. We're not fighting the left here in Tennessee. This isn't some crazy left-wing, loon, Obama-appointed judge. This is a Trump-appointed federal judge who took the bench in 2018. Now let's look at some of the things he had to say in this ruling, which I find incredible. And by the way, before I get into this, please bear with me because there's some really important things that were said in this decision. But what I'm about to read, the first part of this, forgive the lewdness of what I'm about to read. But it's important that it's read because this is in the court document. All right, this was from the trial, and I'm reading this just so that you understand. The judge is fully aware of what's in front of him. Okay, there's nothing that we're unsure about here. The judge knows exactly what he's ruling on, and that's also something important to note. So this is a testimony from Miss Rodley. Miss Rodley is a board member of Friends of George's, this LGBT theater that puts on these drag performances. And this is per her testimony to the court. She's telling you what they do. Miss Rodley also testified about 3 of the plaintiff's past productions without playing the videos at trial. The first one is a skit from Drag Rocks involving Rod Stewart. Miss Rodley testified that the skit involved a portrayal of sexual acts between 2 performers, one of whom was wearing tight black pants, and he is wearing a penis that is over-exaggerated so the audience can see it's there. The second is a performance entitled Bitch, You Stole My Purse, which is about a lot lizard, a truck stop prostitute, if you don't know what that is, and involved blowjobs and possibly having sex as well as pooping in somebody's purse. And the third is a skit entitled Dick in a Box, which involved 2 people presenting gift packages where their penises would be. Penis is in a box. It's got tissue around it. It's really hard to see if it's erect or not. Plaintiff claims these performances could fall under Title 39-17-901s under various clauses to include, quote, representation of excretory function and depiction of male genitals in a discernibly turgid state. How you doing so far? Okay, so this is a board member from this theater that is now testifying to the court what they do at this theater. So there are no secrets here. This judge knows exactly what they're looking at. But I want to take you to this other statement. Let me find it here. This is incredibly important when you consider what was just stated to the court. Ms. Rodley's uncontroverted testimony was that plaintiff puts on, quote, 3 productions a year to raise money for fellow LGBTQ nonprofits and provides a space outside of the bars and clubs where people can enjoy this art form. So the first thing is this board member is acknowledging that their organization's intent is to take these performances outside of the traditional adult-oriented business establishments, right? And to take it into other venues. And to top that off, she also testified that most of their shows are held at the Evergreen Theater within Shelby County with no age restrictions. All right, so the table is set, right? This is what's before Judge Thomas Parker out in West Tennessee. Here's a gay theater. They put on drag performances. You heard all of the sexual nature of what they do. They traditionally do it in a theater where there are no age restrictions. All right, let's continue. Another really important part that needs to be understood here is the plaintiff in their own testimony describes that it would either need to cancel the show or add an age restriction to an event that has always been open to all ages. So I wanted to read this because it's important to note the plaintiff in this court case acknowledges that at the end of the day, really their free speech is not being limited. They can still express and do what they want to do in front of adult audiences. They submit to the court that shows that may have traditionally been open to all ages would now need to be restricted by age. Well, yes, that was the point of the law. The point of the law was to make sure that any of these sexualized performances that are happening across the state are indeed age restricted, because we know that they have not been. And again, the plaintiffs here acknowledge that all they have to do is add an age restriction, which is not a limitation on speech, but let's continue. The judge then expresses concern that perhaps an officer could abuse the wide discretion that he supposes that exists in the law, given an art form like drag that some would say purposefully challenges the limits of society's accepted norms. So I'm giving you bits and pieces here because this is a 70-page court order. But what the judge is saying here is really important. He talked about the Miller test. He talked about, which was a Supreme Court decision, I believe, in 1973, that really talked about the idea of communities being engaged in determining what's appropriate in their communities, what's obscene and what's not. It was a legal way to begin to bring definition to what is obscene by applying community standards. Well, what this judge is saying here is that perhaps the community standards might be changing, and that's okay. Again, he says an art form like drag that some would say purposefully challenges the limits of society's accepted norms. So let's not be too concerned, right, whether or not the material is obscene, whether or not we are presenting sexual acts in front of children, because that's the point of drag. It's here to purposefully challenge the norms. Let's keep going. I want to point this out because this is where things are really, really concerning on how this judge is interpreting the law. If you recall, it's been stated and restated. This law does not restrict drag performances. This law does not restrict sexualized performances. This law does not restrict obscene performances. The law only does one thing. It restricts these performances in the presence of minors. That's it. It's one of the most common sense bills that actually came out of the General Assembly this year. It's really quite simple. The problem is this judge doesn't see it as an age restriction. He's interpreting it as a viewpoint discrimination. In other words, he's saying that the legislature did not pass this law to protect children, but perhaps because they have a viewpoint and a bias against drag performances. And that's an important distinction because the court recognizes as precedent that viewpoint discrimination is a blatant and egregious form of content discrimination. And that is where he's getting the basis for his ruling. But I want to read this part as well because it's important. Here, the judge is making a distinction between two current laws we have on the books in the state of Tennessee, both having to do with adult entertainment. The AERA that he's referencing here is a law that has been on the books for decades, which regulates licensing for adult entertainment venues based on obscenity, based on it being harmful to minors, and the type of content being produced in those places of business. The AEA is the Adult Entertainment Act. That is the current law being referenced that passed this year that prevents these performances, even in public places, from being presented to minors. So I want to read this and go back to something I said in a prior video. What this means is that the AERA and the AEA share similar language but operate differently. Even though the male or female impersonator language appears in both, it employs no viewpoint discrimination in the AERA context because it regulates the business owner. All right. What does that mean? The law that regulates adult entertainment businesses regulates the business owner. And I want to make something really clear here because I did a prior video on this, and so I'm gonna harken back to this. We have a law on the books that regulates businesses that require a business to have a license to be an adult entertainment venue. That's been on the books for quite some time. And this judge is stating that regulating a business in such a way, he does not find that offensive to the Constitution. In fact, he finds that upholds the First Amendment. And if you recall, I talked about HB 30, which was a bill that would have put the nail in the coffin on this particular issue in the state of Tennessee. Anywhere these drag performances would have taken place, that law would have required any business putting on that type of a production to obtain an adult entertainment license, meaning that the law would not have regulated the performers and their speech. That law would have regulated the business entity in terms of the types of things that it does in its business establishment. Again, which the judge seems to find appropriate. That bill passed this year in the House, HB 30. 74 of 75 Republicans voted yes on the bill. So almost unanimously, the party voted to pass that bill. However, the bill failed in the Senate. And if you recall, I showed you this screenshot. When the bill got to committee in the Senate, these 6 Republicans in the red outlines, take a look. Look at their names: Richard Briggs, Paige Wiley, Ed Jackson, Adam Lowe, John Stevens, Ken Yeager. These 6 Republicans failed to second a motion so that that bill was even able to be heard in committee, much less get a vote or make it to the floor. These 6 Republican senators killed that bill in the Senate. A bill that, I want to remind you, passed almost unanimously by Republicans in the House. But because of these 6 Republicans on this Senate committee could not even get out of committee, could not even get a hearing in committee. And I would just submit to you that had that bill passed, a lot of these issues that we're seeing right now would have been alleviated in Tennessee. And according to this judge in particular, would have been held constitutional because it regulates the business. But as you well know, since we've been discussing COVID mandates and everything we've been going through here in the state of Tennessee, we don't want to regulate businesses here in the state of Tennessee. But I won't get into that right now. Let's move on. This is perhaps the most dangerous statement made by the court in this order because of the implications it could have down the road, depending upon how the appellate court or the Supreme Court rules in the future. He says, the court finds that this phrase discriminates against the viewpoint of gender identity, particularly those who wish to impersonate a gender that is different from the one in which they are born. So you need to grab onto something here. This judge is buying into this hook, line, and sinker. You have a Trump-appointed Republican federal judge that is making a judgment on the basis that gender identity is a thing. He is making a court ruling, a court judgment. He is making an assertion on the First Amendment of the Constitution based on the fact that he believes it's completely normal. Gender identity is a thing. Moving on, and I got to be honest, in some ways I'm starting to wonder if you may find this judge's name on the manifest at some point to Epstein's Island, because good grief, this next statement, while Tennessee has the power to protect children from harmful materials. So by the way, the judge, it's not lost on him that the Tennessee state legislature certainly does have a duty to protect children. He says it must do so without an unnecessarily broad suppression of speech addressed to adults. So he's concerned, right? He'd rather err on the side of allowing someone to continue obscene speech across the state, right, in front of children, than protect the children. That's essentially what he's saying. The state has an interest in protecting children, but I fear going that far because, boy, I'd sure hate to suppress the speech of these lunatics. Moving on. We're on page 60 now of the court order. Listen to this. Clarity on this point matters greatly to plaintiff. An organization, so this is Friends of George's, the plaintiff in the lawsuit, An organization seeking to provide a space for drag-centric performances outside of age-restricted venues as the expression in its productions would be chilled by the vagueness of the, quote, harmful to minors standard. I'm going to leave this on the screen and allow you to read it while I make sure you understand what's being said. The plaintiff and the judge are both acknowledging that the point of this organization is to present drag performances to minors in places that are not age restricted. Everyone here fully understands that that is the intent. And the concern is that this organization might not be able to present drag to minors because this law is so vague, and it might chill their ability to do so. This is the reasoning and logic that we're encountering here with this judge. This is nothing that we're talking about here, as you can tell, is about protecting children. The only thing on this judge's mind is, well, this gay theater organization wants to present drag to minors. We should protect that. This gay theater organization are just people that like to identify as other genders. We need to protect that. Here's the next one. Money. Money, y'all. Miss Rodley, again, a board member of the nonprofit Friends of George's, the gay theater. Miss Rodley also provided uncontroverted testimony as president and festival director of Mid-South Pride, which hosts the regional Pride Festival. She testified that since this law's enactment, she witnessed a, quote, noticeable decline in sponsorship for the 2023 festival. This is a reason the judge cites for this law potentially crossing the boundaries of the Constitution. Money. Money. Why? Well, since this law is enacted, it's become so hard for us to raise money for our Pride Festival. You know, sponsors that used to give money, hand over fist, well, they don't want to donate anymore, some of them. So we're having a hard time fundraising. What a terrible law. This is in the court order. Money. And finally, don't let this point be lost. Absent Friends, who is another theater, a friend of Friends of George's, gave their testimony. Listen to this. Absent Friends is a theater organization that hosts monthly shows of a musical comedy that incorporates live actors, among them drag performers. Ms. Watson attested that due to their drag performers' fear of potential prosecution from the AEA, they had to place previously unneeded age restriction on their shows, which have historically been attended by families with minor teenagers. Now, the question I have is, well, what was in the content of your show that you thought you might need to put an age restriction? Before this law was in place, you're saying that you were presenting these explicit performances to minors. And since the law passed, that you've now needed to put age restrictions on these shows. I'm thinking, great, the law is working. The judge is presenting this as evidence in the order as to why he's making his decision to deem this law unconstitutional. Gosh, because these poor people are now having to put age restrictions on these explicit performances, which, in all of this leaves me scratching my head. I hope you've seen a trend here on everything that we've talked about through this court order, which, by the way, again, is 70 pages. We're just hitting a few nuggets that I've pulled out for you. The issue clearly on the side of the plaintiff, they acknowledge, and the judge, is not that the expression is banned from happening. It's simply that the expression is being banned in front of children. And the question that I keep asking myself is, why is it so important to put these performances in front of children? And to some degree, I can explain away the theater's desire, because we're seeing that's what this agenda does. It's coming after our children. But why is the judge buying this argument, right? That's what I can't get over in this whole thing. How is it that a Trump-appointed judge is buying the argument that it is important? It's important for the right of these individuals to express themselves per the First Amendment, that it's required that they're able to do so in front of minors. Why? Why does it not satisfy their constitutionally secured right to free speech to express themselves in front of other adults? Why does that not satisfy the First Amendment? Why is it that these performances, because again, recall, that's all this law does. The only thing the judge throws out all these things about content discrimination, viewpoint discrimination, vagueness, the broadness of the law, and that's unconstitutional. It's not broad at all. It says you can do whatever you want to do, just not in front of kids. It's that simple. But there is a need on the part of the gay theater and on the part of the judge, apparently, to satisfy the Constitution, to present these things in front of children. So I haven't done a lot of digging, but I just wanted to know, who is this judge? It's worth noting that Thomas Parker, who was appointed and took the bench in 2018, appointed by then President Trump, says Judge Parker, this is 2018 at the time, was a shareholder in the Memphis office of Baker Donaldson, so a very, very large law firm. He was a shareholder. He's part of Baker Donaldson. Well, look at this, right? Now, you want to talk about viewpoint discrimination. Baker Donaldson, of whom which this federal judge was a shareholder, has a massive website devoted to diversity and inclusion and diversity scholarships, and I mean, just all the things. You name it, they're for it. But Baker Pride caught my eye. I mean, it's not only that they support the LGBT community, they've even branded, these people have gone way down the rabbit hole, right? They even have a brand called Baker Pride. But here's what's interesting, because I was thinking about these festivals and the money nature of what the judge had to say. Baker Donaldson, again, of which this judge was a shareholder, has financially sponsored, per their admission, for years, pride festivals, including festivals in Memphis. So let me get this straight, all right? You have a judge that is claiming that the entire state legislature, elected by you and me, are bigots and are exercising in viewpoint, they're not protecting children, they're exercising in viewpoint discrimination against the LGBT community and drag performers by passing this law. Yet, is this judge not practicing viewpoint discrimination from the bench? It seems to me that this judge has a viewpoint, that he is on the other side of the aisle on this issue. He's not only sympathetic to the plight of these drag performers, they have financially supported pride celebrations in Memphis, in the community where this gay theater exists. The plaintiff in the court case before his bench. Is that in no way a conflict? Maybe not. But it seems clear to me that this judge is maybe exercising a little viewpoint discrimination. Talk about the pot calling the kettle black, right? Just some final thoughts here. This is not a court ruling based on the Constitution, based on law. This was an affirmation of a judicial activist. This was his own affirmation of his beliefs on gender identity, on his beliefs of funding the LGBT agenda in our communities. This is a judge who deemed it more important that people are able to express themselves sexually, then it is important for the state to have an interest in protecting our children. I would advocate for someone like this to be impeached. It's for idiots like this that the impeachment power actually exists. The problem is, if the House even were successful in impeaching someone like this, currently it would be President Biden who would appoint the replacement. So, for right now, we're stuck with a degenerate on the bench. But this is what you get, right, when you simply trust a party or a man to do the job. We need people in leadership that fear God. We need men and women in our legislature. We need governors. We need law enforcement. We need DAs. We need judges who fear God. This judge clearly does not.